Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners curious to learn more about the hottest issues in these fields. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Foreign Investment and National Security Committee of the Antitrust Law section. And today's episode is on upcoming changes to the laws governing foreign investment in Europe. This episode is the latest in our ongoing series examining the rules governing foreign investment in different jurisdictions. Investing in a foreign country happens in a variety of forms for a variety of reasons. In October, the European Commission issued its fifth annual report on foreign direct investment, or FDI, screening in the EU, which is a nice snapshot of trends in foreign investment in the 27 EU member states for the prior year. Foreign investors invested nearly 3.89 trillion euros in the EU in 2024. The US was the top foreign investor in the EU, followed by the UK and Germany. Now, total FDI transactions were down 8.4% from 2023, which itself was a 23% decrease from 2022. And this was largely attributable to decreases in greenfield projects. Like greenfield investments, what we're talking about is a type of FDI where the investor builds entirely new operations or facilities or businesses from the ground up, as opposed to buying or merging with an existing local company. Greenfield investments were down 19% in 2024, even as M&A transactions saw a slight uptick by 2.7%. 3,136 transactions were reported by member state national FDI authorities. 41% were subject to formal screening, while 59% were not. And this was apparently distorted by Sweden's new and somewhat ambiguous FDI Act, which I'm sure our guests can explain to us in greater detail. So controlling for the amount of transactions that were, out of an abundance of caution, reported to Sweden, 67% of the cases reported required formal screening. Of the transactions that were formally screened, 86% were cleared unconditionally, 9% were subject to conditions, 4% were withdrawn, and only 1% were subject to prohibition. So in terms of raw numbers, of the 3,136 transactions that were reported, 100 ended up subject to conditions, 50 were withdrawn, and 10 were subject to prohibition, while the rest were cleared unconditionally. As percentages, this distribution largely tracks with the last 3 years' worth of data, although as more regimes proliferate and the scope of existing regulations expands, the number of deals that go into each of these categories has grown significantly since 2020. But there are major changes afoot to the rules governing foreign investment in the EU. And to walk us through what's happening, I've invited a couple of guests who know a great deal about the new regulations that are poised to go into effect. First, Christine Graham is a partner at the law firm Bryan, Leighton, Paisner, and is part of the firm's global antitrust and trade team based out of London. Christine is a leading advisor on complex global foreign direct investment review. She's a co-founder of the EU FDI Association and a member of the United Kingdom's expert panel on its national security and investment screening regime. She's also a vice chair of the Fins Committee, which is co-producing this podcast. Andrew Hill is a senior policy advisor at the American Chamber of Commerce to the EU, where he leads the organization's work on competition, tax, public procurement, and FDI matters. Andrew has been closely involved in advocating for U.S. industry's perspective on the new foreign investment screening regulations. So welcome, Christine and Andrew.
Hello, great to be here.
Yes, lovely to be here today. Thank you, Anant.
Thank you.
Before we get into the proposed changes to the law, Christine, why don't we start off with some background on the original motivation and purpose of the EU's FDI regulation?
I think that's a great starting point. And thank you again for hosting us today and allowing us to participate in this very timely podcast around the evolution of the EU FDI regulation. I think it makes sense for our listeners to really take a step back in time and look at the EU framework itself, which is quite a unique when you compare it to other jurisdictions. So if we go back even as far as the 1960s, there were many countries in the EU that didn't have any formal FDI screening mechanism in place. Instead, what you found was sector authorization requirements or the equivalent. So if I look at Brazil today, for example, that reminds me of what it must have been like at that time, because there is a jurisdiction where it's very much based on a sector authorization. For example, a target company engaged in energy, for example, there you might have to go through the relevant energy regulator to get authorization for the investment, but there's no such formal mechanism in place. EU at the time was very much open for investment, as it is remains so today. But I would say that during the period of between 2014 and 2017, there was this wave of foreign and state-backed acquisitions of EU companies with cutting-edge technologies and critical infrastructure and assets. And this was raising concerns, not just about the competitiveness of the EU and the implications for EU sovereignty, but as well as that there were concerns around member state security and the broader security of the European Union. So in February 2017, you had three countries, Germany, Italy, and France, who voiced concerns to the European Commission about these third countries, if you like, who were making investments in these critical assets and key technologies. And they were raised with the European Commission as a way of, how can you help us to add additional protection and to defend European interests? And at the time, the European responded. In May 2017, 3 months later, it came up with a proposed framework for allowing for the screening of foreign investments, allowing member states to exchange information with the European Commission, but equally allowing national member states to maintain their own sovereignty and prerogative to identify what is a national security interest for them. So it was a framework to enable cooperation rather than to be a one-stop shop for all types of FDI screening in the European Union. And then in September of 2017, the European Commission went a step further and they came out with a proposal for the screening of FDI inflows to the European Union. And I remember at the time, Jean-Claude Juncker, who was the former president of the European Commission, he gave his annual State of the Union, where he made a very important speech about the new legislative proposal. And at that point in time, it's important to remember, we only had 12 member states with formal screening mechanism. So not, again, we have currently 27 member states, not even half with former regimes, even at that stage. And there again, it was very much, we're open for investment, but we're not naive free traders. And if a quote from him was, if a foreign state-owned company wants to purchase a European harbour, part of our energy infrastructure, or defence technology firm, this can only happen in transparency with scrutiny and debate. And from that, the Commission adopted through the Council and European Parliament the EU FDI regulation that we have now, that was adopted in March 2019 and became applicable in October 2020. So that's how we got here, if we're looking back. So we currently have the EU FDI regulation. Its purpose at the time was, as I said, by way of background, it's just really to allow for the exchange of information between member states, and where there is concerns regarding national security or public order that is shared amongst the member states and the European Commission. It was to allow increased transparency, foster a coordinated approach to screening across the European, whilst respecting member state sovereignty and making ultimately the final decisions on investments in their own territories. So that was where we got to. And this came into force, as I said, in October 2020. And under that legislation was required to conduct a review of the legislation after 3 years. And so it carried out, as you'd expect, a public consultation. It had targeted questions to stakeholders. And broadly, it was functioning well. However, it identified significant challenges with implementation of the regulation that then prompted calls for reform. I think for readers out, for your listeners who are, interested in exploring a bit more into this area, I would definitely flag the OECD report in 2022, as well as the 2023 European Court of Auditors report, where both reports identified significant limitations in the existing mechanism. And we don't have time to go through all of those today, but I will definitely highlight a couple of them to our listeners. So first of all, the key issue with the regime of the regulation was that there was no mandatory requirement on member states to set up their own FDI screening mechanism. So essentially, you had member states had the freedom to control or not to control foreign investment. And so you had ended up with this fragmentation amongst member states, where some did have screening mechanisms and others didn't. And this was a real loophole in the regime, because if you were coming from a hostile country and you were seeking to invest in the EU, well, then notionally you could acquire a target company in one of these member states without a foreign screening mechanism and use that as a way of gaining access to the single market and then ultimately to critical European assets. So there was a ways to circumvent the rules. And so that was a concern that they did have about the current regulation. And noticeably in 2019, the Commission, published lots of communications encouraging member states to implement foreign investment screening regimes. But again, it wasn't legally binding because the legislation did not impose a requirement for member states to have a screening mechanism. The second issue was, in terms of those jurisdictions that did have screening mechanisms in place, there was a real disparity between the scope of those regimes in terms of the sectors that they covered, the types of transactions, the types of investors that they covered. And again, it was just leading to lots of divergent outcomes across the European Union. And again, it's just simply compromised in a way the effective protection of the single market. So that was another gap in the system that they had to address. And another one I will just mention briefly is the regime itself didn't cover investments by EU subsidiaries that were controlled by foreign companies. So it only looked at third countries. So, for example, if you were a US company and you had an Italian subsidiary that was acquiring critical assets in Italy, then that wouldn't fall under the regime because it's an EU entity that is acquiring that asset. And so again, there was a gap in the system. So as a result of this information gathering and these reports that were published, it was decided that they should make some reforms to the regime, and they were needed. So where we came out then after this was in January 2024, the European Commission, as part of the European Economic Strategy, came out with a proposal to revise the EU FDI regulation. And the Commission made it very clear at the time that this was a way to, it was an evolution, as they said, as opposed to a revolution. They sought to evolve the regime as opposed to seeking to make radical changes, because, as I said, it was working well, but there were limitations into how well it performed. And some of the key changes that I'll just mention under the proposed reforms were introducing of the mandatory regime for all member states. So that was top of the list. And it's quite interesting, I note that today, in fact, we have 27 member states now because the UK left. Of the 27 member states, it's only one jurisdiction now, which is Cyprus, which does not have a mandatory screening regime in effect, but that is due to come into force next year. So by the time this regulation is fully in effect, we will already have mandatory screening regimes across all member states in any event.
Good. Come on, Cypriot.
Yeah. So we're just waiting. So we're just waiting on the Croatian that they had. There was the other one actually more recently, but they did come in just in the middle of November with entry into force with their legislation. So just one more to go. And then revised proposal from the Commission introduced a minimum sectoral scope. So all member states were required to screen these certain sectors. And again, it's a minimum levels of scrutiny, and of course, leaving to member states to determine, actually, we want to introduce more. They could still do so, depending on their own national security interests, but there was a minimum of sectors that they wanted to cover. They also covered that gap that I mentioned about direct investors who are ultimately controlled by individuals from a non-EU country. So that was another change that they proposed, as well as various mechanisms to harmonize procedures such as timelines, standstill obligations, judicial review of decisions. These were key areas for the Commission to allow not only for coordination of efforts across member states, but also for investors and companies seeking to invest in the EU. Because as you can imagine, with all these different regimes, there's so many different rules and they're not the same. So and navigating it can become very complex. And so another step taken by the Commission was to seek to harmonize as much as they could those types of rules. So that's where we ended up in January 2024. And I will hand over now to maybe Andrew, take us through where we got to on the next stage. which takes us into the trilogues for the next stage of revision.
Wonderful. Well, thank you so much, Christine. Thank you, Anant, for having me on and putting this together. I just first really want to reinforce the point that you made, Christine, that I think is vital to understanding where we are, which is just how incredibly different national regimes are in Europe and the true compliance cost this creates. I mean, I think most people listening are probably involved in EU FDI screening in a way, or you might have colleagues who are. So you understand that if you have, I think at this point, 26 separate regimes in Europe, all with different, filing requirements, sometimes in national language, and all different practices. And keep in mind, this isn't competition. This is FDI. This is, the risk assessments are done with intelligence communities, not with economics, consultants as well. You don't just need, from the company's perspective, to engage maybe one lawyer and they'll call up a few people in the member states that you're notifying in. You have to engage many. And even within those national legal communities, there's a lot of specificity around whether you've worked with these regimes, whether you have case law, all of that. So it's been a tremendously difficult, really a black box transaction review instrument for industry here. And this isn't just bad for companies, but it's very difficult for member states themselves who see, risks evolving, becoming more cross-border. The point you brought up earlier about having incongruent investment regimes, this is also difficult for member states who really wanted to step up and be brave in imposing an investment screening regime. They don't want to see then all of their investment diverting to another member state with perhaps weaker ones. So, following the economic security strategy, a lot of feedback, some really good reports. We saw back in January 2024 that the Commission proposed the new foreign investment screening regulation. Important that it's a foreign investment, not direct investment, because this also loops in now a lot of European companies that might be involved as well. So just a quick run through of how the legislative process works in Europe. The Commission puts together a first proposal here. It then goes to both the Parliament and the Council to deliberate. U.S. listeners might think of it as, Congress and Senate. The Parliament's, democratically elected. The Council is made up of ministers in theory, but more in practice, actual FDI screeners. So when we saw the Council negotiating and they were able to really substantively reach a deal a little bit earlier, back around this time last year, it was really the screening teams coming together and working amongst themselves a system that worked along with the Commission.
Oh, Andrew, just to clarify, so the council, is it composed of FDI screeners from member states?
Yeah, so I mean, there's a lot of different configurations and levels, but for the most parts, when you have the technical dialogues on what's being negotiated, when you're actually talking about, let's say, what does effective participation mean, the jurisdictional test being used under the screening regulation, that's probably going to be done by the actual screening teams coming into Brussels or dialing in online to discuss it. However, you have also attachés here in Brussels negotiating it, usually from more of a procedural or political level. You have ambassadors, even finance or ministers of economy or foreign affairs. So it's really a good reflection of all of the different organizations involved in FDI screening in different member states. So I guess running through the discussions here, starting with the Commission who put forward the proposal, an important point here, you touched on, Christine, as well, is when they came up with this proposal, they were really mavericks. Nobody thought that this was possible. I remember even a few months earlier having conversations with industry and lawyers and saying, would a process like this, a sort of minimum harmonization approach ever work in Europe? And people said, no, there's no way that the member states would ever give away any sort of sovereignty or any sort of, decision-making capabilities.
Andrew, I'm still a bit skeptical. I'm still a bit, I think that, it's a tough line to walk, isn't it? Because at the one hand, as I said, the European Union, because it's made up of all these different member states and they all look after their own national interests, it's very hard to agree amongst 27 what are we agree in terms of harmonization and procedures, because at the moment all the timelines are different, the scope is different.
Oh, yeah.
And so coming together to reach a uniform approach is challenging. So like you, I find I was skeptical at this. I still remain to see what comes out. But it seems like a really tough challenge to reconcile all these differences and find a way forward, which actually improves security of the European Union while also enabling independent jurisdictions to, determine for themselves, is this their national security interest or not?
And you even see that on the size of the legislation. I think the first screening regulation was something like 14 pages. This one will, probably be around 50, 60. That's a lot of new stuff. But really the commission was understanding of this. So what they were trying to do is essentially say, look, we have all of these different screening regimes in place. How can we at least come up with a common structure for screening, for companies? How do you make sure that, you're more or less doing the same sort of legal work, notifying the same types of documents in different member states? And how are we making sure that member states are more or less looking at them the same way? They can arrive at different decisions, but how do we make sure that there's some uniformity there? Likewise, they also wanted to see the cooperation mechanism would more or less sort of require member states to have a trust-based approach to cooperation. In the current system, every member state has a different process for how they work in the cooperation mechanism. Some really love it, some don't like it as much, some listen to the commission because they help with capacity, some don't. They wanted really to sort of put forward a proposal, in my view, that's just made member states more accustomed to working together in hopes that maybe in the future it would be more. So, the approach that they take also really tries to make member states think a little bit more about critical priorities at the EU level. And this is most visible in the scope, where you see it's really aligned about critical infrastructure and technologies defined within the economic security strategy, including this very famous now critical technology list, Annex 2, Paragraph 2, which is essentially a copy and paste of an earlier list, which is used for risk assessment. Christine, you know more than anybody that it gave a lot of those in the business community a lot of ire, since it was not defined or set up at all for being a basis of mandatory notification. But the Commission was making a point there. Look, no matter where we end up in the scope, it needs to align with what we as a community are looking for.
Yeah, absolutely. That's the issue when you have to do all these filings and you come across the definition. What is critical technology? What does that mean? And especially if it's a new regime, like, we're talking about Croatia and Cyprus, I'm sure they'll have different sectors and how it's defined. And we've seen issues you mentioned at the start and about Sweden. It led to so many notifications, and the time was because the regime seems so broad. And I think it's only through time and as regimes get better and more experience, then they can more precisely define what is the actual issue we're looking for here. So yes, I think the community was aghast with the list of sectors, but I think it's also, as you're going back to that point you said I said at the start about there was a lot of concern about foreign investors in Europe and seeking to basically sweep up all these assets, critical technology. And so there's a real nervousness about, we need to make this as broad and as long as possible to make sure everything is covered here. And we only have one bite of the apple. And so it's just like, just do it, make it as broad as possible. So, and I think that was a moment we're still looking, obviously we'll come on to that, how they've revised that, but yeah. A key point.
No, exactly. And just to sort of illustrate here just how broad that is, I think they use a term data processing items who might use a flash drive in the course of day-to-day business, right? So that just wasn't workable, I think, for a lot of people. And the council, I think, really saw this and they appreciated the approach. It took them probably a little bit of time to really get on board there. But from their perspective, they were also dealing with an issue here that also, Anant, pointed out too, which is they're just receiving, in many cases, way too many notifications. We talked about the 1,808 real cases. If we take out Sweden, who has sort of a different situation at the moment. If only 56% of those are actually screened, that means a good amount of them are not really relevant. They might be a bit preemptive. And member states don't like this. Nobody likes to do, lawyers and screeners are the same. No one likes to do the check the box work of, okay, here's a investment in a random paperclip company. This obviously doesn't raise concerns, but let's just make sure it doesn't. They don't like that. They want to spend more time on really risky, complex cases as risks get more and more complex. So what they wanted to do really is make that a little bit more understandable and aligned. And they said, we don't need that overlap. We don't need the complexity that comes with that. Let's just align it around that. And that was really a big innovation. And a lot of people said, okay, well, this is narrowing the scope. Not really. It's just, it might narrow it in terms of, the amounts of paper that you're reading, but it's really just aligning it with a much more, regularly updated and, specifically defined list as well.
It was quite a pragmatic approach they took, I
Mhm.
thought, because, I know this dual use list, it's well established. So practitioners use it for export control purposes. We all know it. And it's a list you can update. So if there are concerns about a sector that you haven't covered, then you can update the list. And so that was one way to address the concerns that others may have had, that, we have to, cover everything. Yeah, that was a good step forward.
Oh, definitely. And they also made some edits, like, allowing for some flexibility for member states in the cooperation mechanism, while also allowing for sort of accountability. They made some steps towards additionally clarifying some language that might not have made sense around the definitions, including for one sort of scoping out, for the most part, internal corporate restructurings, which is a big sigh of relief for many companies. And they more or less sort of reached their main negotiating position back in December of 2024. They had a bit of a pause. The council runs on presidencies. It started really under the Hungarians. They were super passionate about it. The Poles didn't really see it as much of a priority. And then you ended up with the Danes, who really carried it on in the trilogues, although it concluded under the Poles. The parliament started really taking a look at it in December of 2024 as well. An important dynamic about the parliament is, under the current system, you have a lead committee, the International Trade Committee in this case, that's responsible for essentially coming up with a negotiating position that reflects all sort of the main parties' interests within the parliaments, or within the parliament, or at least in Euro terms, the political groups consisting of multiple parties, depending on sort of national affiliations. And they also need to an extent, take into consideration, but not necessarily account for, the positions of other associated committees. And these ranged from those who had sort of a sectoral focus, maybe on sort of financial policy, to those who are looking a little bit more at sort of internal market instruments and sort of legal processes as well. Since the parliament is made up of politicians, they didn't really bring the same pragmatic expert approach that the council did. They saw this really as an opportunity to do two things. One, make sure that their own sort of sectoral priorities were accounted for. And then two, also really try to push for some more Europeanization in the screening process here. So really starting with the scope, because this is where I think a lot of the contention was, at least, within the trilogues. It's really hard as a politician to negotiate a tool like this and not deem everything as critical. You don't want an investment in a nail company to end up with defective nails for a sinister reason that causes all shares to fall apart, and then your constituents to come back at you and unelect you. That's terrible, right? So when you're sitting in the meetings with the MEPs, the members of parliament, you could literally point around the room to just random inane objects and say, is this critical? And they'd say, probably, yeah. So the approach that they took was a little bit more broad in the end. They took a reasoned approach, but it was a little bit broader. They had some issues with the dual use list. So it was heavily debated whether that's an appropriate basis for the majority of mandatory authorizations. This is mainly due to sort of the issues with the Wassenaar Agreement. For those who are unfamiliar, the Wassenaar Agreement was negotiated with Russia. So if Russia is within this framework, they can't really update the dual use framework significantly. But also you had a number of item-specific recommendations there. And these ran the gamut from environmental decontamination technologies that the Greens really liked, to social media companies, to even elementary schools, secondary schools, and universities. These typically weren't designed by lawyers, so they were a little bit more broad. They usually say, then let's say with a train, they just say train, or they'd link to a very broad list of something in another legislation that related to trains. And this created a lot of risk, I think, for the legal community, where you would have to over notify a significant amount of products, even if they didn't have a national security nexus there.
From the outside looking in, the parliament seemed to just take a very different approach to the council, in the way that they, for the reasons you gave, Andrew, just seek to extend everything, to widen the scope, to seek to have more harmonization, so that it becomes more predictable process.
Mm-hmm.
They even sought to give the commission more powers, didn't they, to act on its own initiative, to intervene if member states disagree. So you can clearly see why a member state would not like that. So they tried to make it more harmonious, I suppose, in terms of a consistent EU-wide approach. But doing so, they pushed it much further than the council or the commission had advocated. So I thought that was interesting.
Oh, definitely. And you see this as well with sort of the approach they take to the risk assessment. This was a very big area of concern for the parliament. They saw the concept of security and public order being in the member states only as a little bit difficult for a community. And they wanted to really try to remedy this in a way by giving the commission more powers in the cooperation mechanism, and also really coming up with quite extensive risk assessment criteria, which I think a number of them probably made their way into the trilogues, since it's a little bit less of a burden for member states to take on risk assessment versus accepting something on scope. But you're right, a lot of these issues in questions are quite difficult to negotiate. Member states don't want to give up sovereignty, but also the Commission and the Parliament don't want to back away on these being European issues of concern.
And in terms of the geopolitical context which we're in, you could see why they were pushing for those aspects to be covered.
Oh, indeed, definitely. So now we've reached the end of the trilogues. We have a few months left until we really get to see what the ultimate file is. Right now, they're going through a very nerdy and quiet lawyer-linguist period where they're going to, one, work on the recitals, but also get the text ready to actually be legally applicable. And then afterwards, we'll probably see around a year and a half implementation timeline. So we'll really see this coming into play in 2028. So I guess, Christine, what do you think the implications are going to be on your end? I'm interested in sort of hearing about what you're telling clients, what you think it's going to lead to.
Well, I think based on we obviously we had the last trilogue was actually a week ago today. It was on the 11th of December, and after that there was this press announcement about what they had position they had taken. And they're obviously now determined that there will be this introduce a minimum sectoral scope. So these are some of the areas that you mentioned, Andrew, in terms of the dual use. But they also mentioned hypercritical technologies, critical raw materials, critical entities in energy, transport and digital infrastructure, electoral infrastructure, and then a limited set of financial system entities. So in terms of this, obviously it's much narrower. They've actually focused on some of them will come at no surprise, like key infrastructure, like energy and defense. But it also gives discretion for member states to add to this list. It's not the definitive list, so they can add more to it. So I think, what I could see, therefore, is the likelihood of more filings. As you can imagine, with an increase in sectors, I think that it could potentially lead to more filings. And I also say, one point that they obviously seeking to address is this definition of foreign investor now. So again, we're targeting EU companies that are ultimately owned by third country, non-EU. This also will lead to potentially more filings coming in. Now, in terms of the process itself, it seems to me by having more harmonization, they've mentioned they want to have a new shared database, which will be accessible to the member states to facilitate more exchange of information and experience. And therefore, as a result of this, I think companies, need to be mindful that they will be disclosing more information that potentially could be stored in this database. And so when you're doing multiple filings and, successive years, you've got to be consistent as well. And, the information you're providing, that will be now potentially stored on a database. Again, we don't have much more information on what it will be, but it's something to be mindful of. Another thing I would just mention from my perspective is, whenever you're doing a complex cross-border M&A deal, it ultimately could trigger potential filings in multiple jurisdictions. And so it's getting yourself ready, because I think the intention is obviously to ensure more harmony across that process. So, you file in the same time with all member states. So if that is the case, then it's just, identifying where there are FDI filing requirements very early on in the process and making sure that we have the information to make those filings in time. So that's something that I'll be advising my clients. There's another need here to ensure that FDI is one of the key areas of due diligence that we conduct from the outset.
Christine, are these issues that your companies and investors don't need to worry about until 2028 when the final regulations go into effect, or are there things that they need to start doing now in anticipation of the new regs?
That's a good point. And so I think it's as Andrew mentioned. So there'll be a bit of legislative changes that'll be made, I imagine, to the final text, and that obviously has to be adopted into various languages and then published in the official journal. So we could see in the first half of 2026 it's a published version of this, and then they've got 18 months. Member states have 18 months to implement it. I would say that we could see some regimes like Germany might, once they have that text, in their hands and see what it means, they may make some revisions to their regime, because there's some regimes which do need to make changes and have been considering, but have been holding back until we receive this final version. And so I'd say it would really much depend on the jurisdiction. Croatia and Cyprus might wait. They've just introduced one, so they might give themselves a bit longer. But others, I think, like Germany, who've been waiting for this, I could see them potentially coming, forward a bit sooner and making changes that align with the requirements in the regulation, and also implement any further that they need to protect their own national interests. So that's something I would see happening. Would you agree, Andrew?
Oh, most definitely. I mean, one other trend that I'd touch on, and this is a little bit separate from this regulation as well, is, in the recent, so the Commission put out almost the next step in the economic security strategy, which is now this economic security. And they're calling, some people are calling it the doctrine, other people are calling it, a communication, whatever it may be. I don't think anyone quite knows. And in there, they talk a lot about the Commission's role providing more risk assessments and monitoring for the cooperation mechanism, right? And I'm not quite sure if this necessarily needs to begin or have an impact once the screening regulation is in place, right? And they talk about it in two ways. One, they want to set up a non-notifiable portfolio investment screening mechanism with supervisory authorities' rights, and presumably this might allow them to, speak informally with screening authorities and say, hey, you have this, potentially, sub-threshold transaction happening over here. You might want to call that in. But also they're looking at the risk of cumulative investments, right? So if maybe one investment in a sector by a certain country investor, we don't actually quite know what's going on here, would if one investment by them might not raise concerns, maybe multiple could, right? This is sort of similar to what we've seen historically in Europe, maybe in like the German solar sector, where you're so slowly getting taken over by foreign investors, and it ends up hurting, the industry itself. This doesn't necessarily need to start, right? And I'm not quite sure if we need to wait all the way until 2028 to see the cooperation mechanism becoming a little bit more robust. Member states feeling like, okay, well, we're going to have to cooperate more eventually. Why not start cooperating now?
Right. Absolutely. Yeah. I thought it was quite timely. They published that just a week before the final trilogue came out on 11th of December. And the UK also published its economic, and the US as well have one too. Then they just published.
Japan.
The US. It's interesting that it's, as you say, Andrew. FDI is just probably one tool in the toolbox for the Commission. They will look at other areas. They're seeking to have more collaboration between public and private businesses to see how they can improve economic security. So I think it's a question, for companies out there to be very mindful that there's probably more to come in the next year or so. It's certainly, it's the EU is no different to the rest of the world, where they're really focused on protecting their economic security in these geopolitical times.
All right, so let me see whether I have this right. So the trilogue process has ended. New language, final language, or proposed draft final language to come out. Member states have 18 months to review it and maybe continue to modify. And then we'll expect the final regs to come out 18 months after that. So sometime in the late 2027, after which we expect the laws to go into effect. All right. So there's a lot to work with here. We tried to end these episodes with some key takeaways for practitioners. Let's start with you, Andrew. What are some of the key takeaways from your end?
Key takeaways from my end. One, I mean, look, I'm an optimist. I think things are going to be better. At the end of the day, investors will hopefully know, will hopefully have access to a little bit more of an aligned sort of notification system around Europe. There's going to be sort of a common phase one review period. So you should know within, we don't know the final number, but probably 45 days or less, whether your transaction is going to create an issue or not. And member states will be able to cooperate more in a way that supports the economic security, national security of Europe, and also generally the transatlantic community as well. So that's one takeaway. Things are probably getting better. The other takeaway is there is still a lot to be done. This is a evolutive process. There's still a lot here that member states can diverge on, from concept of control to how they actually design their screening regimes. And if there's not sufficient attention to how member states are actually really implementing things here and making sure that they remain committed to doing this in an aligned and coordinated way in the spirit of really having sort of a low burden but high impact screening system across Europe, we're going to end up back in square one.
Christine, what about you?
And you're optimistic, Andrew. And I'd say for me, it's simply, it's a key reminder that FDI should be front and center of any deal that any investor or any practitioner is working on, which has a cross-border element, especially in the EU. We have 27 member states now coming into effect, even before this, comes into full force, that have FDI screening regimes. So in the immediate term, just be mindful of that. They all have divergent approaches. It's great if you love FDI, but for investors, it does cause a bit of a heartache. So I would definitely bear that in mind. I'd say just watch this space as well in terms of other regimes that are probably more sophisticated, like Germany, and others who might just use this as an opportunity now to get aligned with their approach. As Andrew said, I'm hopeful. This will lead to better coordination, more predictability for investors in the community, because we all need these timelines, because they're so divergent. It does create issues. So I'm hopeful, but it's a wait and see.
As someone who went through the Digital Markets Act process, I can tell you that the EU regulatory timeline goes by more quickly in real time than you're expecting it to. So for our listeners, whether you're in-house, whether you're advising companies who are looking at investing in Europe, whether you're a company looking at making an investment directly in Europe, such as a new data center, these laws are going to come to effect. They're going to apply to you. So both of you, Andrew, Christine, thank you so much for walking us through the intricacies of what's going to be a regulatory system that's going to impact lots of companies, lots of law firms worldwide. To our listeners, be sure to subscribe on your podcast platform of choice and stay tuned for more episodes in our ongoing series examining FDI worldwide. And we'll see you next time on Trust and Trade.